Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we're going to turn our attention to a contract provision that often gets overlooked between IT service providers and their customers, but which can have huge implications for their insurance. What brings this to mind is the recent ruling by a Delaware court dismissing lawsuits brought against a software service provider following a ransomware event back in 2020 that impacted thousands of its corporate clients. During the attack, threat actors had compromised the data of many of the software provider's clients, and this in turn caused those clients to provide required data breach notifications to their own customers. Well, a couple of cyber insurance carriers who reimbursed those businesses for their losses decided to go after the software provider who suffered the attack in the first place. They filed suit to recoup the funds that they had paid out to their policyholders, a process known to insurance geeks as subrogation. The case depended upon their being able to prove breach of contract or negligence on the part of the software provider. Well, the court was having none of it. The judge ruled that the fact that a data breach had occurred and that the software provider's clients incurred expenses was not enough by itself to make out a claim that the provider had somehow breached its contract with its clients. The judge also tossed out the negligence claim brought by the carriers, stating that the mere fact that their policyholders had to comply with various legal requirements following the breach didn't establish that the software provider owed those businesses any sort of duty. Even the fact that consumer class actions are currently pending against those businesses in other states that recognize a common law duty to safeguard confidential information didn't help the carrier's case in Delaware, a state in which the courts have yet to expressly recognize such a duty. Accordingly, the court dismissed the case on grounds that the plaintiff insurers had failed to state a claim upon which relief could be granted. Now, to be fair, this isn't necessarily the end of the story. The carriers could go back and revise their complaints with greater specificity. But I think what is notable here is a topic that the court didn't directly address, and that is what I want to focus on here. See, each of these engagements between the software provider and its clients is presumably governed by some sort of service agreement, and vendors often ask their clients to agree to waive subrogation on behalf of their insurance carriers. It's not clear whether that was part of the service agreements here. When such a waiver has been given by the client, that effectively precludes the insurer from taking legal action against the vendor, provided that the client's insurance policy allows them to offer that waiver. Otherwise, the client is either in violation of the contract if the carrier proceeds with subrogation, or they're in violation of their policy if the carrier is prevented from doing so. That's why it's so important to marry up the contract wording of your service agreements with your insurance policies. And this is a detail that the parties don't always pay attention to. Did you know that insurance law doesn't even appear on most bar exams in this country, and few law schools require students to take a course in it prior to graduation? It's a shame because so much civil litigation depends upon the availability of insurance to defend and settle claims, and the fact that the lawyers negotiating these contracts aren't always focused on insurance doesn't make it any less important. So don't let this become the Achilles heel that brings down your risk management program. For the most recent edition of our paper, coverage currently available in the market, which discusses subrogation and many other policy provisions that you should be aware of when negotiating cyber insurance, please don't hesitate to reach out. You can DM me on LinkedIn or email me at david.finz@alliance.com, and I'll be happy to send you a copy. And if your current broker isn't having these conversations with you, maybe it's time that you discover the more rewarding way to manage risk. Thanks for watching.